West Bengal Assembly election results are out. The day new CM will be swearing in has also been decided as 9th May. But the problem here is the CM that lost the election is saying that she will not resign. She says she has morally won. But this leads to a very important question. Can CM refuse to resign? And if that is the case, are there any constitutional measures to address the situation? Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we will be looking towards the constitutional norms, the constitutional provisions which are present to address this situation in front of West Bengal Assembly election results. So let us begin with understanding what has happened. So as of now, the results of West Bengal Assembly elections have been announced. An overwhelming majority has been in the side of Bharatiya Janata Party. Now, the other party which has lost election, that is Trinamool Congress, they are saying that there were electoral irregularities, centre was interfering and the election commission is biased. That is why we will not accept this defeat. Morally, we have won, and this is the same party who had the chief minister up and until now, Mamata Banerjee. She is refusing to resign. Now that is why we are trying to understand that what is the scope of governor's power in this, if any, constitutional conventions and norms, and how this transition of power or transfer of power will take place. So the first thing that we will do is start with understanding that what is the constitutional basis of chief minister's office. Now, we have to straight up read Article 164, which gives the provision of pleasure of the governor. Now, Article 164 says, ministers hold office during the pleasure of the governor. When we are looking at this particular article and we try to understand the constitutional provision, chief minister is also appointed by the governor, and the minister will hold the office during pleasure of the governor. So in this, technically, governor can dismiss the whole ministry. So this might make you seem that governor has the outright power. But no, this is not the situation. The governor cannot act arbitrarily. The real legitimacy of the ministers lies on the fact that if they hold the majority in legislative assembly. If they do not hold the majority, then the legitimacy is not present. And also it depends on the democratic mandate, the electoral mandate which has come out as the result. So what governor will be deciding will be based on this. So a chief minister can remain in power if he has majority in legislative assembly and if he has the democratic mandate, even if it is not at the pleasure of governor. And this is not something that has been established only by constitution. Over the years, Supreme Court observations have clarified that the misuse of governor's power in appointment, so that comes also in judicial review, and how the legitimacy needs to be defined, that also has been put forth. So all in all, chief minister remains in power while enjoying majority support in the assembly. If they do not, then of course that is where the governor can dismiss them. They are liable to the dismissal. Now we have understood the constitutional basis where chief minister office lies. But there's whole another story we have to understand when we are talking about refusal to resign. So if we are looking at refusal to resign, the first thing that can come up in order to address this situation is the fact that governor is going to seek clarification. How? Governor can ask CM, do you have the majority? Do you have the majority in the assembly? And if they say yes, they will have to prove the support in the assembly. Correct? As of now, that assembly does not exist. We will move to that factor as well. The second step is, if they want to prove the support in assembly, they would have to do it through a floor test. The governor has to conduct this floor test inside the legislative assembly. The MLAs will vote and that will help in determining the majority. If the floor test is lost, the government has to resign. And then when we are looking at the floor test comes the finality which has been given by the Supreme Court through a very clear principle that majority which will be tested, it will not be in Raj Bhavan. That means governor's residence. That will not happen there, the counting, the numbering. It will happen on the floor of the house, that is the assembly. So the transparency also needs to be ensured. And this is not something that has been established through one judgment. Over the years, multiple judgments such as S.R. Bommai versus Union of India, Nabam, Rabia case and others have been the ones which have dictated this very simple direct principle. So as of now, it seems that it is not that complicated. The governor will seek clarification, there will be a flow test and then the state government will step down. Apart from that, there is another angle that is involved that we need to talk about is the role of assembly. I said the assembly is not valid anymore. Why did I say so? Article 172 states the duration of state assembly. The state assembly tenure is 5 years from first sitting. So if we look at Bengal Assembly timeline, we see the first sitting happened on May 8, 2021. 5 years is May 7, 2026. That means the tenure of the assembly expires tomorrow. So either way, this assembly is not valid to vote for the flow test. And what needs to be done? That if assembly is dissolved automatically after 5 years based on constitutional understanding, then the existing government does not have any democratic basis. They cannot even talk about a flow test. Nobody will even question them if they have majority or not. And if the new assembly needs to come into power, it needs to be constituted. How it will be constituted? Based on the results that have just come out. So as of now, it seems like that what is being asked as a question, what will happen now, that has been very clearly and in a proper detailed manner defined by the constitution. So there is no big problem lying in front of us. Now another question that arises here, that what will be the possibility, what is coming up next, the procedure we have understood. So one possibility which is being talked about a lot is president's rule, but you have to understand that as of now, based on norms and provisions, it is not required. But if there is extreme constitutional breakdown, that is also a possibility that we can consider. Can you tell me in the comment section which article gives the provision of president's rule in the constitution? Now based on this, the last thing that we need to understand, based on this, it is clear that as of now, new MLAs will take oath that will lead to formation constitution of the new assembly. The governor will invite the majority party leader and new CM will be sworn in and the government will have to prove their majority. In this, the role of assembly which has already dissolved, the CM who is not anymore the CM seems very much limited. But if that is a question in this context, governor can dismiss the CM. It is only in limited cases, exceptional cases, but one of them being when CM loses the majority, which is the case here. If the CM refuses the flow test, then also they can be dismissed. If the CM refuses resignation, which is also the case here, they can be dismissed. So one provision is president's rule, but that will come in only when there is extreme constitutional crisis. Otherwise, the norms are laid out and the future for West Bengal is set in. Let me know what are your thoughts on this in the comment section. I'll be leaving you here with a prelims practice question. Let me know the answer to this as well in the comment section. That was all from my side. Thank you so much.